business is what we call an active asset. An active asset is an asset that one party to the marriage works on a regular basis for a large part of their waking hours. Because it's an active asset, it's not subject to a 50-50 division upon divorce. And we need to keep in mind that that part of the business that was being worked on for the date of the marriage and any part of the business that is being worked on after the party's divorce action is filed is not going to be subject to this analysis. Being that it is an active asset, we use what we call a degree of contribution analysis to determine the value of the business for purposes of dividing it between the title holder and the non-title holder. If you have an indirect contribution, we're looking at the non-title holder's contributions outside of the business only. That means that the non-title holder did nothing within the business, didn't do anything to contribute to the business directly, but did things that freed up the time of the title holder to work the business the way that they did to make it grow and prosper. We're thinking about raising the children. We're thinking about maintaining the home, managing the home, paying the bills, buying the food, buying the clothes, taking care of all those things that are outside of the business that the business owner would have to spend time taking care of, but doesn't have to because the non-title spouse is taking care of all of those things. An indirect contribution in that regard typically is worth 5 to 25% of the appreciation of the business from the date of the marriage to the date the divorce action is started. If, however, the non-title holder is actually involved in the business, that could mean anything from giving advice to the title holder, showing up at events that involve promoting the business, and therefore, because they're there and they're shaking hands and talking to people in the same way the title holder is, or they're actually going into the business itself and doing things like filing or answering telephones or managing staff or balancing the books, or even being there on a day-to-day basis, helping the title holder make day-to-day decisions or larger executive decisions about the business. Now they're making direct contribution to the business. Direct contributions typically are worth 25 to 45% of the appreciation of value of the business from the date of the marriage to the date of the divorce action. 10% of the value of the business will always go to the title holder. That's because we always look at the goodwill, the name, the effort, the branding of the owner of that business, and therefore give it a 10% credit off the top. However, the other 90% is now going to be subject to the analysis that I just described. Homes are subject to a similar kind of analysis as business is, except that when we talk about when it was acquired, whether it was acquired during the marriage, whether it was acquired prior to the date of the marriage, whether or not assets that were acquired prior to the date of the marriage, a gift that's provable, or an inheritance is used to acquire the property. So let me step back and break down those three main pieces of what we would call separate property. Premarital asset, such as a bank account up until the date the parties get married, is going to be separate property because it was not the product of the marriage. We have to remember that a marriage is an economic partnership. There can be no economic partnership without a marriage. So anything that was acquired outside of the date of the marriage or prior to the date of the marriage is going to be that person's separate property. The second category of separate property is the gift that's provable to one party of the marriage that was received during the marriage. Or it could have been received prior to the date of the marriage, but we like to think that that's part of the premarital separate property. But a gift that's acquired during the marriage is provable. Think about a check that was written for $10,000 with one party's name only on it, and it was deposited in an account bearing the payee's name only, not the other spouse as well. If it's deposited into a joint account and it is left in that account for more than 24 to 48 hours, it will be deemed a gift to the marriage. New York in particular affords something that we call a convenience rule that enables somebody to deposit a separate property check into a joint account, provided that they immediately remove it from that account within a day or two, will preserve technically the separate property character of the deposit. That's risky because in this day and age, why would you put a check with your name on it into a joint account when, if you know that that check is coming, you could open up an account in your own name to be able to keep the separateness, but it can be done. The third category of separate property would be an inheritance. An inheritance is something that is given to someone by virtue of someone's death, and here again, provided that the spouse's name does not appear on the title of the asset that's being inherited, it will maintain its separate property character. So what does this mean in the whole context of purchasing a marital home? Typically, when people buy a marital home, there is a down payment. Many times, that down payment is comprised of joint assets, such assets acquired during the course of the marriage. That's marital property. That's not an issue in this division, and we'll get into that momentarily. But if someone contributes their separate property into the purchase of a marital home, upon divorce, if the property is being sold altogether, neither party is going to own it after their sale, or one person is buying out the other person's interest in the home, there is going to be a credit going back to the person paying the separate property into the marital home to buy the marital home at the time that the closing occurs. The remaining portion, after satisfying the mortgage, the taxes, any liens that may be on the property, any fees associated with the sale of the property, whether it's mansion tax or it's a transfer tax, the net proceeds will be divided equally between the parties. Why equally? So a marriage, much like a business, will reside in the storefront, and the business is operating within the storefront and doing whatever it's doing within that storefront. A marriage is operating in a house. Somebody's going out and earning, or both parties are going out and earning money to maintain that house. One or both parties is painting the walls, cleaning the house, doing the dishes, doing things to maintain the house and keep the upkeep of the house. The courts are not going to get into who did what and who did more. They're going to presume that it's the joint efforts of the marriage that warrants the equal distribution of the proceeds, the net proceeds of the marital home. One thing that the courts may do, as with other assets, is they may award one side, the lesser money spouse, a little more than 50%. It's largely because if the person who is what we would call the earner is making a significantly greater amount of money and the lesser earner is making little or no money in comparison, because that higher earner is going to earn money to make up for what they're giving up and the other person won't have that opportunity, they may skew the division of the asset accordingly. It's not a frequent occurrence, but it can happen. Investments are divided generally 50-50 because they're a passive asset. Much like a marital home, a passive asset appreciates by itself without effort of either party. Because it didn't require the effort of either party to get that asset to appreciate, or depreciate as the case may be, the courts feel that it's unfair to give one party greater amount of that asset by virtue of the fact that the asset just happened to appreciate without their effort. There are some exceptions. If there is a premarital portion of the investment account, or there is a provable gift that went into the investment account, if the investment account is an inheritance that does not contain the name of the other spouse on the account, it will also be dealt with or deemed as a separate property asset. With respect to any premarital portion of that account, it is important that the parties maintain a statement from that account showing how much was in that account at the time they got married. Otherwise, it won't be able to be proven how much that asset was separate property. This depends upon the facts and circumstances of the parties. One vehicle that can be used, but it must be used with separate property, and I'm typically thinking of it in terms of the marital home, is that a trust containing the separate property is created with the separate property deposited within the trust, and then the trust buys the marital home. At that point, both parties to the marriage are going to be deemed tenants, essentially, and have no ownership interest in the property, and therefore no claim can be put on that asset. The same thing would be true with an investment account. If you put it in a trust, here again, and if it's separate property, there's that part of the trust that's used, the dividends and the interest, that's used to buy something during the marriage, depending upon how it's purchased, what is being purchased, can maintain its separate property character. And it goes back to the analysis of, is it paying for a marital expense? If it's paying for a marital expense, the separate property will be converted into marital property. If you deposit liquid assets into a trust that's separate property, it will maintain its separate property character, provided, however, that the interest and dividends, for example, are not being used to pay for marital expenses. Whenever you use a separate property asset for a marital expense, a day-to-day marital expense, not a capital expense, and we'll get into that distinction momentarily, you automatically lose the protections of the separate property expense because it's hard to track down what that money was used for and how it was used and how to, claw it back. On the other side, if you use separate property asset that's in a trust for the income, for example, for a capital improvement, you take $100,000 to put a room on the back of the house or to put down as a down payment, the separate property will maintain its character. If in the ordinary course of the marriage, you decide to buy, for example, a motor vehicle, and you buy the motor vehicle through the business, the motor vehicle will not be a marital asset, but instead a business asset. So there's a strong argument that the car would not be subject to division under standard marital practice rules, but it would be part of the value analysis when looking at a business and valuing that business for purposes of dividing it as an asset that's active with a degree of contribution analysis.